enforcement for Wednesday, April 9th, 2014. Adoption of minutes. Anybody have any additions or deletions to the minutes? No changes? Okay. I make a motion that we adopt the minutes as they are.
Second.
Motion continues. Let's see. For the agenda, staff, yes, sir? Oh, that's true. Thank you. I got a second. All in favor?
Aye.
All opposed? Motion passes. Deletions in from the agenda. Staff have any changes?
I do. Excuse me. Item number 3C1, Jessica Morris. I'm pulling it. She's obtained her permit and paid her citation. Item C2, C, Soray. The citation's been paid and the problem has been complied.
Could you repeat that name again?
Soray.
Excuse me.
Citation number 247T, as in Tom.
Okay. Thank you, sir.
I'll make a motion we approve the agenda as modified.
I'll second that motion. All in favor?
Aye.
All opposed? Motion continues. Sherry, let's swear everybody in, please.
If you're going to testify, if you stand, please. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
Thank you. Okay. Case number CE-4467, Anders Nyquist.
Case 13 CE 4467 came before the board March 12, 2014. The violator, B. Anders Nyquist, trustee for Nyquist Trust Number 2, was found in violation of City Code Section 3831B7 for a stagnant swimming pool at 1177 25th Street and given until March 27th to correct the violation. The violation was corrected on March 25th. The city requests the board find the violation has been corrected and is asking for enforcement cost of $333.71. Mr. Nyquist has drained the pool. And covered the pool.
And that's satisfactory. It meets requirements.
The requirement was to drain the pool and cover the pool, yes. Meets the
Okay.
requirement.
Mr. Nyquist, did you have anything you wanted to say? And you've been sworn in?
I have. First of all, I'd like to thank you for hearing me again on this matter. I met with Ms. Sanderson at the property. The violation's been abated. I've actually done everything that staff has asked me to do. When I received the certified letter, I came into the department. I asked to speak with Ms. Sanderson. She was out in the field, and I spoke with Mr. McGarry that afternoon. And we had informal conversation about the violation. He went and pulled the file. I told him that I hadn't received any previous correspondence from the city except the certified mail, and that I was receiving my first notice that I was receiving a fine. Well, at that time, Mr. McGarry, we agreed that he was going to prepare a document, stipulation that I bring the property into compliance. The document that I originally got from Mr. McGarry was erroneous as to the address, so I couldn't sign it. I wanted to sign it, but I couldn't because the address was wrong. It cited a different address than the address of this property. Then I was out of the country, and I came back, but I did meet with staff. And after I met with Mr. McGarry, I said one of the first things we were going to do was they were concerned about, mosquito larvae hatching and all that type of thing. So the first thing I did was install the mosquito larvae preventative. And another requirement in the stipulation agreement or compliance agreement was that I get an electrical permit from the city, and I did do that as well. But then we found out after getting the electrical permit that the pump systems had been down and the filtration systems had been down for so long that it was going to be so excessive. Probably the easiest thing to abate the problem would be to go ahead and pump out the swimming pool, which we did, and covered it. Now, in the stipulation agreement, it says payment of costs, and it has the amount would be zero, and the inspection fee would be zero. Now there's, I guess, $333.71 in claimed administrative fees. And one of the issues that I have with the affidavit of costs, and you probably have in your packet as well, there's an affidavit of costs from Mr. McGarry, and then there's also an affidavit of costs from Ms. Sanderson. But when I met with Mr. McGarry, and we sat down very informally to speak about this, and again, this is the first time I've ever had a problem with the city. I've been a resident 35 years. So I sat down casually to speak about it. But now I see that I was billed for a half-hour time for $96 an hour from Mr. McGarry. He never mentioned to me that these might be billable visits. And furthermore, the preparation of the compliance agreement, he has 2 hours time at $96 for $192. Well, one, there's a lot of problems I have with this. One, the compliance agreement was an error. Two, if we rely upon the compliance agreement, it says that there should be zero in payment of costs. But moreover, I think that by someone who's not a member of the bar to prepare a legal document that requires notarization for recording, you cannot bill a third party for it. It's against Florida statute. It circumvents the attorney, the barcode. And I think that the preparation, one, for $192 of that is excessive, and two, it should be stricken because it's a violation of, it could be interpreted as practicing as an attorney and billing for preparation of documents to a third party, a member of the public. So I would ask that be stricken. And the meeting I had with him, he didn't, when I sat down with him for 10 minutes, he's got a half-hour time on his charge. But as a member of the public, you'd think you'd be able to come in and sit down and talk to a public official without getting a bill for it. And I did everything that was asked of me. And I just think that this fee of $333.71, albeit cost, is excessive. There was no harm done here. This was a swimming pool that was pumped out. Nobody got hurt. And even more so, Ms. Sanderson, when I met you there, we went over and above. There was garbage there that we removed. It was not cited on the form. It was not required, correct?
Correct.
But we did remove it, and you said thank you for going over and above.
I said thank you for removing the garbage, correct.
So, I really tried to act in good faith, and just considering, everybody has a first time up, and I'd rather be doing something else right now. I'd be at work, but. And when I was here last time, Mr. Howell said, this is not a punishing board, but this seems punitive, and I did everything that was asked of me.
I have a question for you. You said that it violated Florida statutes. Could you be more specific?
Well, someone who's not a member of the Florida Bar cannot prepare legal documents and bill a third party for them unless they're a licensed attorney.
How do you know that?
I researched it. I mean, it's common knowledge, too.
Thank you.
I'd just like a couple of points of clarification. The error on the admission of violation waiver of the right to hearing and agreement to correct, as he said, the address was wrong. Listed as the violation address was Mr. Nyquist's office address. And as soon as Tim realized that, he effected that change. And we're not trying to be punitive. We are not asking for the initial 50. There are no accruing penalties. We're just asking for the enforcement cost.
I have a few other questions, Mr. Nyquist.
Yes, sir.
And a concern. You've pumped all the water out of the pool.
Yes, sir.
You had said that your contractor said that it would rise. You're aware, you remember that statement? If it was not filled with water?
We had discussed with a pool company before we did it that there could be cracking of the shell of the pool
Okay.
from the groundwater pushing against
Right.
the shell of the pool.
I recall that. Okay, but you're aware of that then? That could happen? If there's no water in it?
Yeah, I guess, but I mean,
Okay.
we took
All right.
action anyway.
Okay, the second question I have, in light of the fact that there were heavy, heavy rains, do you think those cinder blocks and those other flat blocks would be strong enough when the water does accumulate to keep that tarpaulin or whatever plastic from going into the pool itself? Should it be, the bottom line is, should it be secured better?
Well, what we're doing as an ongoing effort, I have my workers, and they're directed to go check that property every Friday before close to make sure the tarp's in place. We may, now that we start getting back into a rainy season, we may have to just periodically, pump this from rainwater, which is not a big problem because it's basically just a big sump pump that you drop down there.
No, but I'm talking about the fact that accumulation on top of that blue plastic may collapse that whole thing, just given the fact that I see a cinder block and a couple of flat blocks. I don't know if that's going to be strong enough with the accumulation of water, especially what we had last night.
You know what we might do is probably get some 2x4s and make a T and go underneath it and put it up so it sort of slopes down more. That might be a better engineering.
Sounds like a great idea to me. I would consider that if I were you.
Right.
And Mr. Pizzacilli, with all due respect, I think if this did come up again, it would be a separate and repeat violation. I think it appears that, at least for temporary purposes, he's done quite a bit. Yeah, the T's probably a good idea to keep from having a repeat violation, but I mean, if you met the standard for code here, then that's great. And seems like you've done a lot to try to get there. I think you would have probably have just cleaned it up if you had the option instead of pumping it out and risking the pool popping up. And I have another question for the record, Mr. Commit, because I think I'm getting my what can be reduced and what can't.
Well, I understand the city is asking now to waive the initial $50 penalty.
Correct.
Okay, so we're only talking about the costs, and here you do have a violator that is basically contesting the amount of costs, so it does give you some discretion on the costs. What do you feel are appropriate to be included in the assessment of costs?
Okay. And because I know there are costs associated with the city and their ability to go out and check on these matters, I'm going to err toward the suggestion of the city to find that you've corrected the violation and that a total of $331.71 is due to the city for enforcement cost. And I'm up for anybody who doesn't agree with me, but I'll look for a second on that motion.
What's your opinion on the validity of his statement that the city can't prepare a legal document and fill a third party?
I mean, city staff prepares documents all the time. I think what his point is that he shouldn't be charged for the preparation of documents because Mr. McGarry is not an attorney. Honestly, I haven't researched that because he's really not preparing them for Mr. Nyquist. He's preparing them as part of the enforcement process. So whether or not that objection would be sustained or not is, I honestly don't know.
But it's a
in this
billable charge
situation.
to me.
Was that part of the $50 that was waived, or?
No, that affidavit of cost is Tim's time and staff's
No.
time.
Right.
$192 for the preparation of the agreement. And again, I mean, you know, a layperson I cannot go and prepare an agreement for you and then bill you for it unless I'm an attorney.
And I would agree with that if you came into Mr. McGarry for the preparation of a document and said, could you prepare this for me? And then he charges you for it. But you didn't come in as a client. You weren't his client at the time. And that would be problematic. I just don't know the answer for sure that this could come under that, him acting as an attorney for Mr. Nyquist, because obviously he's not acting as his attorney. He's preparing a document which the code allows for in the course of a prosecution of a code violation.
In
So,
a sense, I was a party to the document that he was preparing, and I'm being billed for it on behalf of the city. And I think that's improper.
May I speak?
Sure.
I think we would be on thin ice to set a precedent, as Mr. Nyquist suggests. Any other person coming in here down the road would refer to the Nyquist situation, and I'm not in favor of tying Mr. McGarry's hands. I sympathize about the $300 plus, but we cannot tie our hands at this time or at any time if we're going to keep Vero the way we want to keep Vero.
I concur.
I have a question. How many times did you go out to the house?
Do you have a copy of the affidavit of cost? Attached is
I just closed
record.
it.
There is 3 hours, .19 minutes of time involved with the preparation of the case, documentation, investigation, re-inspections.
In all
Honestly,
those,
I really don't have a problem with Ms. Sanderson's affidavit of costs. You know, and I mean, if you want to, but I mean, when you start getting into $96 an hour, which is what Mr. McGarry was charging me, when I could very well have been dealing with her, and I came to see her, but she wasn't here, and he took my meeting instead. But again, it was very informal. Yeah, come on, sit down, let's talk about it. Not like, well, you know, this might be a billable visit at $100 an hour. I mean, you know, it's not. But it's just it's excessive, and I think it's guised to be punitive.
May I ask another question? Mr. Comment? In order to preserve our precedent and yet perhaps collect some money from this situation, could we reduce down somewhat the cost that this man is complaining about? And yet preserve our precedent that we have the right to do that?
well, every case is on its own facts. And here, I don't know how often we've had this come up. I mean, Mr. McGarry certainly should have the opportunity to support why he's asking the costs he is,
Okay.
and you might want to hear from him.
Well, let's ask him. Mr. Nyquist, would you mind if Mr. McGarry spoke for a moment?
No, not at all.
Thank you.
Yeah, let's set the facts right, and I agree here. You're going to undermine the planning department. The document, these are done, when that gentleman came in, Mr. Nyquist came in, he wanted to not go to the code enforcement meeting. And I said, the only way you can do to go to that meeting that day would be we could enter into this agreement that you would be willing to admit a guilt and violation to go ahead and do, and that's what we did. So it was an informal meeting. And the understanding was if you signed the agreement, came in compliance, there wouldn't be any charges. We don't charge. I've never charged people for these things. But Mr. Nyquist did not do that. Mr. Nyquist never got back to me after we sent him a corrected one. I never heard from him. We chased after him. And for us for people to do that, and I spent my time to put that together so we'd have an agreement, and then to renege on that, because basically he showed up at the March 12th meeting, if you recall, with a permit in hand. He hadn't done anything yet. And the permit was going to find out it was electrical. So he just saved another month. He was supposed to be in compliance by that time, and he wasn't, and now he's back. He's finally in compliance. We don't like to punish people, but I think it's a bad precedent if you have people come in and tell me these things. I take the time to work with them. We could have had this all over with, but it didn't happen that way. So the staff is very strong about this. It isn't the amount of money, it's the message you're sending to people. And you will totally undermine this process. People come up here and try to get reductions to this or try to get it in a break. I'm very honest about it. It's it's that kind of thing. I've never had that happen before. I can tell you, based on this, I was burnt. That person's going to sit down with me and they're going to sign it right in front of me before I let them go. And then I wouldn't charge them if they don't sign it. But but the agreement was that they were not going to have to go to that meeting, and we continued that process just for that, based on his word, and that wasn't what happened for whatever reason.
You prepared this agreement basically while he was waiting? But
While I was working, we went over some of the details, but I did not prepare it while I was there. No, because I had to write it. He had to go because he had something else to do. So I said I would send him. I had his email. That's what I did. I had the wrong address initially. I sent it the following day for the address. I heard nothing about that. You think if you got the agreement, you had the wrong address, and you were willing to sign it, you would have given me a call. All right? I'm just saying that I don't think this amount of money is that much in this kind of case, and it sends the proper message.
Thank you, Mr.
And I had my
McGarry.
say. Thank you.
Thank you.
Just to rebut that, I don't think it's arbitrary that again, I mean, this might be a matter for the Attorney General's office for the state of Florida for clarification, but I don't think that he can, as a non-member of the bar, prepare a legal document for recording and bill me for it $96 an hour. I think it's he's practicing as an attorney without being licensed. And I don't know what kind of precedents you want to set by. I think it would be easier than to have me contest this somewhere else than to just say, listen, the guy complied, no harm, no foul, nobody got hurt. I just have a problem with a $200 bill for a preparation of a document that, one, was in error, and two, it differed from what we spoke about. We spoke about a common stipulation to do this, to clean up the violation. But the way the compliance agreement read, one, I admit I'm a violator, two, I waive rights to a hearing. I mean, it was a loaded document. It's not anything that we talked about in the office.
Did you call him after you received the document that was wrong?
Unfortunately, I was out of the country then. This is when I wasn't, but as soon as I got back, I did. As soon as I got back, I did. And when I received the certified letter from Ms. Sanderson, I responded the very next day.
Well, here's my thoughts. You have a right as a Floridian and an American citizen to go to court. I'm going to support Mr. McGarry. I make a motion that the fine go through as proposed by the city.
There is a motion on the floor. It hasn't been seconded yet.
Sorry.
Yeah, I can repeat that motion if you like. My motion was that the cost of enforcement of $333.71 stands and that the violation is deemed corrected.
Seconded.
All in favor?
All right.
All opposed? Motion passes. Thank you, Mr. Nyquist. Case number 13-CE-4187, Outlier Investments.
This case came before the board March 12, 2014. The violator, Matt Martise, Outlier Investments, LLC. The board continued the case for 30 days, giving Mr. Martise time to coordinate with the planning and development staff to determine a correction of the violation of failing to mitigate trees that were removed without a permit. The violation has been corrected as of March 18, 2014, by Mr. Martise paying the mitigation amount of $380. The civil penalty on the citation has been paid. Staff would request that the board rescind the notice of assessment, waive the civil penalties, and just assess enforcement cost of $34.23.
How much?
3423.
Did you say the original citation was already paid?
Correct.
Okay, so we wouldn't be waiving penalties. You're just asking to rescind the notice of assessment.
Correct.
Okay.
And continuing penalties if applicable.
So you went out there, I'm asking you to repeat yourself, but you found what? That he's put all the trees required to replace the trees that were cut down, or?
He did not replace the trees based on the calculation of the planning department for the trees that were removed. He did do extensive landscaping because the house is on the market, but by meeting with planning and development staff, in lieu of replacing the trees, you can pay to mitigate, which was the $380 that he paid.
I see, okay. So we're just looking for cost enforcement and, to rescind the notice of assessment and any continuing penalties.
Yes, sir.
And the violation was corrected as of March 18th.
And that the violation was corrected as of March 18th.
Correct.
Okay. I'll make a motion that the enforcement costs of 3423 stand and that we rescind the notice of assessment and any continuing penalties because the violation was corrected as of March 18th.
Second.
All in favor?
Aye.
All opposed? Motion passes. Thank you, Officer Sanders. Non-compliance reports. I'm going to go to case number 13-CE-4631. That's Brian Wyckoff.
Requesting a notice of assessment for 13 CE 4631. The violators Brian Wyckoff, 1 West Bank, FSB, cited for the violation of a public nuisance, a large dead tree in the backyard of the residence at 2411 Buena Vista Boulevard. Service of the citation was provided by certified and return receipt and is on file with the city clerk. No request for a hearing on the citation has been received, so a hearing to contest the citation has been waived and the violation is deemed admitted by the violator. The violation has not been corrected as of April 9th, 2014, and the civil penalty has not been paid. Enforcement cost of $70.19 are requested by the city. Yesterday, I had a conversation with Jamie Worley from 1 West Bank. The property is in foreclosure. They have filed what's called the lis pendens to start the process, but do not anticipate that they can move forward with the foreclosure because the property is occupied by the grandson of the woman who is deceased, who is the mortgage holder. So every time the bank tries to do something, they contest the action of the foreclosure. The bank's position is they will not step on the property as long as the house is occupied. Told her that we would go forward with a hearing, and they understand that there's nothing that they can or will do at this point. No contact from Brian Wyckoff, the grandson of the deceased owner.
Okay. Well, then I deem that this property is in co-violation. I move that we find the violation as cited on the citation is continuing and direct to the clerk. We will need to issue an assessment of continuing penalties for a civil penalty of $50, continuing civil penalties of $50 per day starting March 25th, 2014, and enforcement costs is $70.19.
Thank you.
Thank you. All in favor?
I need a second.
I need a second. Thank you. Second and all in favor?
Aye.
All opposed? Motion continues. Thank you. Where do we go? Let's go into board orders. Case number 13-CE-4457, J.B. Jones Jr.
Excuse me. That was Mr. and Mrs. Jones' son that was just in here. She had called earlier this morning and said that she was ill. I'd like to pull this case if I can till next month.
Okay.
He was going to speak on her behalf, but I don't think that he's able to do that at this time.
Can we,
You don't need any board action.
okay. All right, we'll just postpone that then until next month. Moving on, case number 13-CE-4487, Jose Barajas.
This is a request for a board order for case number 13-CE-4487. The violator, Jose Barajas, was cited for a violation of excessive exterior storage of trash, debris, or other materials at 1954 34th Avenue, as provided in the backup materials. Service of the citation was provided by posting in first-class mail and is provided on file with the clerk's office. This violation has not been corrected as of April 9th, 2014, and the civil penalty assessed on the citation has not been paid. Enforcement costs of $42.05 are requested by the city. An affidavit of these itemized costs has been filed with the board clerk, and we request the backup materials be made part of the record. We request the board issue a board order along with initial civil penalty of $50 and the cost of enforcement of $42.05.
There are no continuing penalties on this?
$50 a day.
Yeah, there are.
Per day, every day?
I'll make a motion that there's a violation and the violation continues and that the initial, or the board issue an order for payment of the initial $50 civil penalty, the $42.05 cost of prosecution, and continuing civil penalties of $50 a day.
May I ask a question?
Sure.
Have we contacted personally this fellow or just by mail?
Well, we tried by mail. It didn't work, so we posted the property.
Okay.
And
But he has never come in or tried to make contact?
correct.
Thank you. I second the motion.
Thank you. All in favor? Oh, I'm sorry, Mr. Ryan, do you have a question?
Yeah. At what point in time, when we find these continuing penalties uncollectible, do we place a lien against the property?
Yes.
Oh, okay.
I'm not sure at which point we do, but it is at a certain point that we do.
Are you asking for
That's
like a
what the
time
order
frame?
is, right?
Yeah, once the board issues an order, they have 30 days, basically. Typically, if it's a continuing case, we go ahead and record it in the public records, and by operation of law, that becomes a lien.
Okay, thank you.
But you never heard anything from him. We don't even know if he's getting the mail.
Correct. So I posted the property at the front door.
Okay, did we get a second on Mr. Pizzacilli's motion?
Yes, there was a second.
Okay. All in favor of Mr. Pizzacilli's motion?
Aye.
And all opposed? Motion continues. Thank you. Case number 13-CE-3978, Laura Song.
Staff is requesting an order finding the violation has been corrected for case 13 CE 3978. The violator, Lauren Song, was found in violation of a stagnant swimming pool at 2326 Bonita Avenue. The case came before the board January 8, 2014, and the board found the property not in compliance. The violation had not been corrected. The violator did not appeal the citation or the notice of assessment, and the violator's waiver of hearing was found to be an admission of the violation. The violator did not pay the initial civil penalty, and the board ordered the initial penalty, continuing penalty, and enforcement cost. The violation has been corrected as of March 11, 2014, and the city requests the board find the violation has been corrected and stop the penalties accruing daily as of March 11, 2014.
And that would the order would include an order to pay the outstanding penalties and costs.
Which are, how much?
$50 plus $50 a day.
Be the initial.
No,
I
enforcement
believe I
cost.
have it.
Yeah. Thought I saw a list. Penalties commence on September 24th, plus the initial $50, and then the costs of, what was it, $77.74?
Okay, well, make a motion that the,
I have a question.
I'm sorry. Sure.
Is this another pool with a plastic thing over it with water in it, or no?
This is actually a pool that's been drained halfway, and then they've done a support system across the pool of 2x4s every couple of feet so that the tarp doesn't collapse.
And I don't see any fence around this property. Is it?
The entire backyard is fenced.
Oh, okay.
Any other questions? Make a motion that this property is, this code violation has been corrected and we issue a board order. Plus well, now see, this is where, Mr. Clement, we're going to start the fine September 24th, you said?
Right, it's the $50 initial penalty, the continuing penalty since September 24th up until the date of compliance of March 11th. So we would stop them March 10th.
Okay.
And the enforcement costs of $77.74.
77. Okay. So we're going to have the initial penalty on here, $50 plus any continuing penalties, plus the cost of enforcement of $77.74, and those continuing penalties were stopped March 11th, 2014.
Question?
March 10th.
March 10th, 2014. Thank you.
Has this person made any attempt to contact us? Have we spoken
She
to her?
initially tried to work with us. She has some difficulties at this time and is not able to work much with us.
Okay, thank you.
Do I have a second?
I'll second.
All in favor?
Aye.
All opposed? Motion continues. Thank you. Case number 13-CE-4043, Cecil Bays.
If we could, Mr. Bays owns the property at 2245 27th Avenue and the adjoining lot on Potilla, so can we do both of them together?
Sure. Case number CE-4053 as well?
Yes, sir.
Sure.
Well,
What?
it's going to take two separate orders, so.
Well, that's true, so I guess we can't combine that. We'll just take them one at a time.
My error.
It's all right.
Requesting an order finding the violation has been corrected on 13 CE 4043. Violator Cecil Bays was found in violation of weeds, grass, or undergrowth at a height of more than 12 inches at 2245 27th Avenue. The case came before the board January 8th, 2014, and the board found that the violation had not been corrected. The violator did not appeal the citation or the notice of assessment, and the violator's waiver of hearing was found to be an admission of the violation. The violator did not pay the initial civil penalty, and the board ordered initial penalty, continuing penalties, and enforcement costs. The City of Vero Beach abated the property on March 12, 2014, and the violations are corrected. The city requests the board find that the violation has been corrected as of March 12th, stop the continuing penalties as of that date. Please.
Have a motion?
I'll make a motion that there was a violation, violation's been corrected, and the continuing penalties end on March 11th.
March 12th.
That's the compliance date, so we have to end the day before.
Thank you.
And that the board issue an order for payment of the original civil penalty, the continuing penalties, and the cost of prosecution as found in the notice of assessment.
I'll second that. All in favor?
Aye.
All opposed? Motion passes. Same name. Sorry?
There's the next one.
Oh. Thanks. Case number 13-CE-4053 against Cecil Bays.
Requesting an order finding the violation has been corrected for Mr. Bays. Same violation, weeds, grass, or undergrowth at a height of more than 12 inches on the vacant lot on Potilla Avenue, adjoining 2245 27th Avenue. Case also came before the board January 8th. Property was found not in compliance. The violation had not been corrected. Violator did not appeal the citation or the notice of assessment. The waiver of hearing was found to be admission of the violation. The city abated the lot on March 12th, which corrected the violation, requesting that you stop the fine as of March 12th or 11th. The property is in compliance.
Okay. Make a motion that the property was in violation. The violation's been corrected, that we continue with the civil penalty of $50 and the continuing penalty up to March 11th, 2014, plus enforcement cost of $15.86.
Second.
Thank you. All in favor?
Aye.
All opposed? Motion continues. Thank you. Case number 13-CE-4141, Salvatore and Nancy Sastry.
Requesting an order finding the violation has been corrected for case 13 CE 4141. The violator, Salvatore and Nancy Sastry, were found in violation of a stagnant swimming pool at 1935 37th Avenue. Case came before the board January 8th, 2014, and the board found the violation had not been corrected. The violators did not appeal the citation or the notice of assessment, and the violator's waiver of hearing was found to be an admission of the violation. The violators did not pay the initial civil penalty, and the board ordered initial penalties, continuing penalties, and enforcement costs. The violation was corrected on March 31st, 2014. The city requests the board find the violation has been corrected and stop the continuing penalties as of March 31st, 2014.
Thank you. Motion that property was not in compliance. It is now in compliance with code, and that the board issue a board order and continue the civil penalty of $50, excuse me, and the continuing penalties up onto March 30th, 2014, plus a cost of prosecution for $40.24.
Second.
All in favor?
Aye.
Aye.
All opposed? Motion continues. Thank you. Unlicensed contractor citations. Where's, didn't we have something for, Sherry, what's,
That got removed.
oh, we did. Thank you.
I have a question.
Sure.
Mr. Nyquist's fine, which he would like to have had taken away, what kind of recourse do we have if he doesn't pay it? What do we do?
Keep in mind, it was cost, it wasn't a fine, so those are in a different category. We will go ahead and record the final order if he doesn't pay within 30 days. The problem is the courts don't look as kindly on costs as they do as civil penalties. So in other words, if I wouldn't proceed to foreclose on that lien, in other words. We often, I mean, we typically just rely on the title agents. Whenever properties are sold, they see to it that any of these liens are paid off. Otherwise, it's really cost prohibitive to go after these small liens. And they stay on the books for 20 years, so there's a good chance the property's going to change hands in the meantime. We often collect at that point. While I've got your attention, you did have in front of you a couple of motions having to do with requesting the request for notice of assessment. Sherry and I are still working on some for the ones having to do with orders are a little more complicated, but we're going to work on those and try to give you some. And what we'll try to do is for each case give you a form motion that you can follow with all the numbers and dates and everything in it. We meet before each agenda is put together by Sherry, and we should be able to do that. And actually, you'll have in front of you exactly what's being requested by the code enforcement officer.
Mr. Commit, I may be wrong here, but just thinking back, I know we've already made a motion. Back to the Cecil Bays case, I'm not sure that I enunciated that we were issuing a board order anywhere in my motion, and I wonder if that's going to have any kind of a...
Oh, okay.
Sherry's usually pretty good.
Well, that's what happened. I mean, you pronounce what the result is, and it goes into an order
Okay.
anyway. So,
Okay.
but the motion forms will probably say that.
You'll be amazed how it looks.
Right. Just changes. Anybody else have any questions? Staff, anything? Mr. Commit?
Nothing else.
Sherry? Okay. Well, the meeting's adjourned.